Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Good morning, everybody. Courtney, I'm glad to hear that you have power back. Mike, you're in a hotel in Orlando. Love it. We'll have to talk about poutine soon. Somebody will have to remind me about that. There's been some... Hold on. Why is my cleavage... Oh, because I'm in my other chair. I was like, where's my cleavage? Oh, you'll be there in 2 weeks in Orlando. Oh, exciting. Okay. Anyways, I hope everybody's doing well. I'm sorry I'm a bit late. There's been some Zoom issues today. I'm gonna show you, just so you know. Just give me 1 second and I will have to change the input of this and also make sure that I don't have anything that YouTube Daddy would get mad about. We know how that goes, right, Shane? Right? So check this out. This is the court that we were going to watch today, and look, it was working okay, but you can tell here that this is a different font than normal. And whenever a font changes like that to something weird, it's a tip-off that there's a problem with the program or something going on. Then, first, and also, Leanna, later on tonight, once I sort this out, we are going to talk about your eyelashes. You are not getting off scot-free, but that's going to be for tonight. They're hideous. I'm sorry, girl. You're beautiful, but you don't need those spiders on your face. The reason I mention that is because I also woke up last night with a spider on my face, and I'm not talking about lashes I forgot to take off. I'm talking about a real fucking spider, and now I've been triggered. So thank you, Leanna. Anyways, so you can see here, the font is different, and then it just freezes in this spot.
Great relationships. My mother lived.
And this is on YouTube.
Falling apart. Turns it over. One. Yeah.
So I'm actually not sure if they are going to, if what's going to happen with that. Interesting. That's a Zoom issue, I think. That's what, 20 minutes it's been like that? Oh. But who did we have in here? Them versus her. Oh, we'll see later. Anyways, so, we're not watching that. We have got some other court to watch. Don't you worry. I've got us covered. But, I just wanted to point that out for all the probably 4 other YouTubers that watch this in case they're having Zoom issues as well. Okay. Also, it's, you know, this green reminds me of, the warning or the beginning of a movie. Does it remind you of the beginning of a movie? Christopher Engelby! Yay! Thank you so much, Chris. And I'm drinking coffee from Chris today. Thank you, Christopher. Seriously, this is new as well. This has been popping up a lot in my files lately. And I have to assume that I don't know what's going on. I don't know. I don't know what's going on. Let's see. Oh, I think the font is different in this one as well. So I don't know. Maybe it's fucked up. We'll have to see together. And Alana got the membership. Love it. We're definitely doing 2 shows today. We might even do 3. We'll see how we do. We'll see how we do. I'm feeling a lot better. Could be a chroma signal for the video to start. I don't know how they do it, Mike, but it throws me off every time because to me it sort of indicates like, I don't know, something put together that I didn't put together. But anyways, let's continue, shall we? And I'm not joking about the spider on my face, by the way. Spider was on my face today. What are they mumbling about? Chris, thank you so much. You're taking a vacation from your vacation. How is Galveston? And John Vander needs to straighten his... It's not his camera. I think the picture's off. Vanderhorst. I think it was hot. Ugh. Wait, Chris. Oh no, it's in November that there's the big biker convention in Galveston, right? I believe that's in the first weekend of November. He's a crooked lawyer, Bill. That's funny. Anyways, I thought about that for a second, but I think Mayor would let us know. I hope Mayor's doing okay. I think he's busy. Carol, why aren't you getting notifications? Well, YouTube Daddy is punishing me in a few different ways.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2024-2246-DM, Ashley Lisi versus Marcel Lisi. Today is Monday, October 14th, 2024 at 9:03 a.m.
Court will note the appearance of Ms. Podolsky on behalf of plaintiff, Mr. Vanderhorst on behalf of defendant. The matter is before the court on the plaintiff's motion for temporary custody, parenting time support, use of our family wizard. I guess that last item, Ms. Podolsky, if you saw Mr. Vanderhorst's answer, they said they're not opposed to our family wizard. So being that there's no opposition, the court will grant that. You can proceed with the rest of your motion.
Thank you, Judge. As we stated in our motion, these children are ages 4 and 1. In fact, their youngest just turned 1 within the last 2 months or so. My client and the minor children have been residing here in Calhoun County in the state of Michigan since January of 2024. They moved up here from the state of Georgia. That is where the defendant continues to reside. Since that time coming here and moving to Michigan, the plaintiff, my client, has been the sole and primary caretaker of these minor children. The defendant has not had parenting time with them. He has not spent overnights with them. The children have not gone back down to Georgia to spend parenting time with them. Instead, for the last several months, what he has been intent on is texting and calling and harassing my client more about getting back together rather than co-parenting, being a part of these children's lives.
Wait, he's not on the screen. Paisley, you're the host. You're supposed to know these things. The gentleman she's speaking about is not on the screen at the moment. Also, if you're wanting to try out Discord and you're a little nervous about it, my Discord is probably a good place to do it because nobody will yell at you there for posting something in the wrong place or whatever. There's not rules like that. So some Discords are very strict about who posts where and what and all that kind of shit, and ours is not. So feel free to just go in there and poke around and ask for help or whatnot, and it's a good place. It's good shit, as we would say. Listen, it is difficult to move on sometimes after a relationship ends. It sounds like, obviously, if they have a 1-year-old who just turned 1, I mean, how recently could this split have been? It's also very difficult for young children to be exchanged custody-wise if both people aren't on the same page. Without hearing any more yet, that's what I'll say at this point. Also, Kelly and Ashley do look a little bit similar. Kelly is like the old version of Ashley, right? Like, what I mean, the name-wise, like there was a lot of Kellys, probably 38 to 40 years ago. And then there was a lot of Ashleys like 28 years ago. And now there should be no Ashleys. Yay and welcome! And I'm joking. What is popular now? We could look at that, Courtney, but Bella is very popular. I would say Ella. There's a few other ones that are like top 10. Anna, maybe 10 years ago, Anna. Also, thank you so much, Christopher Engleby. 5 more members. You're amazing. Look at all these names getting them. I love it, love it, love it. Like I said, where I live, there's the Vital Statistics website lets you look up what the most popular names were in any year. And it will tell you, let me just see here. I'll just tell you what the most popular names were in our... They have 100 years of popular baby name data for my province. It's open data. And only first names used 5 times or more in the same year are on the list. So to me, ideally you would want to have a name where it's not that common, but it's also not so obscure. So like my name, Paisley, didn't appear on the list until recently. Even though like I have had my name and there are older Paisleys, it just wasn't very common. But where's the fucking... I don't want to open the whole thing. Let me see if I can find... Anyways, we'll keep playing it and I'll look for the top names.
She tries to send updates, text messages, pictures, video, tries to video chat, though that can be difficult with children of this age. But again, the defendant is more intent on attempting to reconcile and then berating and belittling my client when he's not hearing what he wants to hear. So we are...
Sorry, I found it right away. So the top 10 girl names: Olivia, Emma, Sophia, Charlotte, Isla. Whoa! Isla, I-S-L-A, coming in at number 5 with 128 Islas last year. We have Amelia, Ava, Chloe, that's getting a resurgence. And then Hazel, 111 Hazels. And then Mila is the 10th girl name. 109. So this is my province specifically. We're talking about British Columbia in 2023. Hazel. I can't believe that. Olivia's been on that list for a while. Now, here we go with the boys' names, all right? I just got to check and see if I'm going to be surprised yet, because I knew 2 babies born last year. Anyways, top boys' name: Noah, Oliver, Theodore, number 3, Liam, been popular for a while, Jack, making a resurgence, Lucas, Leo, Ethan, Owen, and Henry. So I'm just saying I think that these are the people having these babies are my age, right? Most of them are in their mid-30s. So they're obsessed with Leonardo DiCaprio, Ethan Hawke, and these are where these names are coming from, I think. I'm being totally honest. Like, that's who's having babies. But you can basically search on this any name. So let's see how many Paisleys there were in 2023. Oh my God. First of all, I'm upset. There was 24. Wow. Wow. Wow! Okay, I'm not going to dox my daughter, but I will say that she also has a P name. And when I named her, there was 68 girls in our province with her name. Last year, she was the less common than my name. My name was more popular. I don't want to deal with all these Gen Z Paisleys that think that they're cool. And Carol, I preface this by stating that this is statistics from the Vital Statistics Agency of British Columbia, and you can look at the racial diversity in British Columbia. It's not all Caucasian by any stretch of the imagination. This includes all children that were named in the province of British Columbia, and we have a pretty high racial diversity. But to be frank, if you're thinking about like African American names, or like that is not well represented in British Columbia. But we do have quite a lot of racial diversity. So anyways, but specifically that was in British Columbia based on Vital Statistics, like what birth certificates were registered that year. My ex-husband and I, when we would go out to dinner when I was pregnant with our daughter, we were going to, we would sit and write out names. And then I didn't access it on my phone at that point, but I would go home and check them and sort of see where they were on the list. I didn't want a top 10 name. No, I didn't mean US and Canada. I just meant specifically the province of British Columbia. I don't even know how many million people do we have in BC. I'll check we have 5 million people in our province. So it's not a huge sample, but it's a West Coast sample for sure.
Are very concerned that at this time for him to have any sort of overnight parenting time with the minor children, they at this point do not know him, especially their 1-year-old, to order unsupervised overnight parenting time with these children would be a risk of harm because they don't know him, because of concerns of him stating, I want to terminate my parental rights. We don't know where his head is at. So we have very serious concerns about that. It, unfortunately, with their youngest would be akin of leaving the child with a babysitter overnight, somebody that the child doesn't know because he has not been there for the last 10 months. So we do understand that he wants to come to the state of Michigan at the end of this month. We have offered parenting time after school. The 4-year-old child is in school. We've offered parenting time after school to be supervised each day while the defendant is here in the state of Michigan, but we do not believe overnight parenting time is appropriate at this time, nor do we believe that unsupervised parenting time would be appropriate due to the significant length of time that he's been absent from their lives. So we're asking this court to order the sole physical and legal custody of the minor children to the plaintiff, that the defendant, any parenting time that is ordered, be supervised and here in the state of Michigan without overnights, and that this court order child support to be calculated pursuant to the Michigan child support formula.
Thank you. Mr. Vanderhorst?
Thank you, Your Honor. The parties do have 2 minor children, ages 4 and 1. The parties were residing in Georgia until the plaintiff mother left Georgia and moved up here with her parents in Michigan. The defendant father did not know the plaintiff's intentions was to leave basically Georgia and reside in Michigan with no intention of coming back and then subsequently file for divorce. Defendant is employed as an investigator in Savannah. Since plaintiff has moved to Michigan, he did come and see the children in April from the 9th through the 15th.
Also, I have to point something out here right away. Kelly, I'm not a fan of anybody leaving a jurisdiction and trying to file in another state to gain benefit. To be honest with you, I don't know if that's feasible or reasonable, but also if he's the child's father, it doesn't actually matter at this point that the child doesn't know who he is. That is a problem to be overcome, not a reason to never see him. Okay? It doesn't actually work well that she left with the kids and now the whole argument is, oh, well, he hasn't seen the kids. Well, he has a fucking job down in Georgia. Also, why isn't this divorce filed in Georgia? I guess she established residency. As we know, the divorce requirements in Michigan be that you are a resident of Michigan for 6 months and the county that you file in for at least 10 days before filing. And that's one of the parties. I don't know.
The defendant father does have a strong relationship with the children, especially the 4-year-old. 4-year-old spent substantial time in Georgia while the parties were residing together. The 4-year-old spent the majority of the child's life in Georgia. Defendant father is a very loving father, and he does care for the minor children. He was inquiring of the plaintiff because he was kind of confused with the situation on why she left and why she's not returning, and also why she shut down all access to the minor children. Defendant really misses his children. He really wants to see his children. So he is proposing he would like to come to Michigan sometime after October 26th. If the court does grant that request for a period of 2 weeks, he would like to spend unsupervised parenting time with the minor children in a hotel if possible. I could get with Attorney Podolsky if the court would order the 2 weeks for October, the specific dates that he would be coming. Any additional parenting time, he's requesting that that be in the state of Georgia. He would like holiday time, especially over Thanksgiving, possibly over Christmas time, until a final parenting time and custody arrangement can either be settled on or if we have to go to trial on that issue. So during the pendency of this action, the defendant is requesting that the court order that the parties be awarded joint physical, joint legal custody. He have unsupervised parenting time in 2 weeks in October, late October and in November, and then holiday time in the state of Georgia. Thank you, Your Honor.
Thank you. Ms. Podolsky, anything else?
Just briefly, Your Honor, I think it's disingenuous to say that he did not know that my client wasn't moving back to the state of Georgia. He was very well aware. These parties have a significant text message history where she has repeatedly told him the relationship was over. And then she didn't file for divorce until she met that 6-month requirement. In fact, didn't file until she'd been here 8 months in August of 2024. At no time during that period did the defendant attempt to file a case in the state of Georgia, attempt to get a parenting time order, a parenting time schedule, engage in any sort of reunification counseling or in any sort of parenting time in general with the minor children.
But we know that in the state of Georgia, there's a very different process for this, regardless of their marriage or not, regardless if he signed a birth certificate or not, regardless if she acknowledges him as the father or not. In Georgia, he has to file AOP, acknowledgement of paternity. An establishment of paternity to establish that. And that is its own lawsuit separate to other stuff. I don't know. I don't like she left, waited the 6 months and then filed. I don't know. Like, would Michigan like that? If she took the children, went to a different state, and then filed there? Like, I don't think Michigan would like that.
he very much knew she was not coming back to the state of Georgia. She's employed here. She has housing here. He knew that was not the case. So at this time, again, we're requesting that any parenting time that is ordered occur here in the state of Michigan and that it be supervised.
Okay, thank you. Well, in this case, it's clear that she has been here since January of 2024, that the defendant has not had really any significant contact with the children since that time. So to preserve the established custodial environment, the court will grant to the plaintiff the legal and physical custody of the children. Court will order support consistent with the child support formula and the guidelines. In this matter, as I stated previously, the parties will communicate through our family wizard. In this case, their court is going to grant parenting time to the defendant if he wishes to come up for those 2.
Not in Michigan. Not in Michigan, Carol. In Michigan, a child born of a marriage is considered issue of that marriage, and there is no need to establish paternity. Regardless of the fact that he lives in Georgia, this action has now been established in Michigan, and he is already entitled. So he'll have to, but she established a custodial environment, and now Vodvarka, which we talked about last night, which is the seminal case which establishes the check marks and lists that you need to hit to make a change in a custodial environment, is basically invoked. So the children have now an established Michigan custodial environment, and to change that, they'll have to hit the Vodvarka standard. But he is entitled to parenting time, and it sounds like the judge is going to allow it. I doubt he's going to allow 2 weeks unsupervised just straight through, but we'll see.
Wizard. In this case, their court is going to grant parenting time to the defendant if he wishes to come up for those 2 weeks. The court will grant him parenting time during the first week that he's here, from after school until 8:00 p.m. with both children. Then the second week, the court would grant that second week continually with the defendant during the time that he is in Michigan. After that, the parties will alternate holidays in this particular matter, and the court will grant to the defendant the Thanksgiving holiday, and that can be extended in this matter, and he can exercise that. If he wishes to exercise in Michigan, he can. If he wishes to exercise in Georgia, he can. It's up to him, and he'll have to make arrangements to accomplish the exchange of the children. The court would order that the parties would meet at a halfway point. I'll leave it up to the parties and the attorneys to figure out where that halfway point is, and that would continue. Otherwise, it's going to be really hard to accomplish any other parenting time other than on the holidays in this matter until we get to summer. So I guess I'll leave it for a period of time for the parties to try to figure out what they'll do at the other times. I will give him the spring break in 2025. And then obviously after that, we should be able to get back to resolve issue of summer before that would come up. So Ms. Podolsky, will leave it up to you to prepare that order and submit it under a 7-day.
Okay, I just want to confirm that second week he's here in Michigan, he would have both children with him, and that would include overnights?
Yes.
And would the party's oldest still be ordered to attend school during that time? So defendant would need to get the minor child to and from school?
Well, he'd have to take the child to school and make arrangements for that.
Okay, thank you. I just want to make sure.
Okay. Okay, thank you. You're free to go. Have a good day.
Thank you.
Kelly, if you want to stay on, I'm gonna call Irons. Joe,
Okay.
I'll put you in the waiting room and call you in case somebody
Now, before you do that, let me talk about it for a little bit. Yeah, the Discord link it expires for safety reasons, John. But Cellulite Yoga Pants posted one a little bit ago. So if somebody was able to scroll up, they would be able to see that. And I will hit play here. One sec.
A few minutes, okay?
Thank you.
Danny, are you on the line?
Yes, ma'am.
Calling case 2018-931D and Danny Irons versus Abigail Irons. Today is Monday, October 14, 2024 at 9:13 a.m.
Court will note the appearance of Ms. Podolsky on behalf of defendant. This matter is before the court on the defendant's motion for parenting time and other relief. Ms. Podolsky.
Thank you. It was really more regarding some issues with parenting time. I will start with the parenting time exchanges. There was a trial in this matter a few months ago, and the parties were ordered to exchange parenting time at a gas station area in Marshall. Unfortunately, the plaintiff father is consistently late to parenting time exchanges. The very specific time for the parenting time exchange was set due to my client's employment and the time that she does have to get to work. So when he's late and he's not communicating with her, she's late to work. She's having to scramble to find her parents to meet her there to then meet him. So we're asking this court to order that the plaintiff communicate when he's going to be late, that if he is 15 minutes or more late and has not communicated with her, that the visit is canceled. And if he has communicated with her and still has not arrived 30 minutes after the scheduled meeting time, that the visit be canceled. Second, as of late, visits have been occurring in the home of a woman in Albion. Her name is identified in our motion. At that home, the minor child doesn't have a bedroom. He doesn't have a bed. He doesn't have a bedtime. There's often no food in the home. We've detailed a contact that the minor child had with my client during a recent parenting time, where he detailed his father and this woman fighting. He had to go out to a vehicle just to escape the fighting, and there was, again, no food in the home. Unfortunately, the fighting is a consistent issue in that home. And again, we've outlined some of the criminal history that this woman has. Since the filing of this motion, the plaintiff has indicated that he is now married to her. He did send my client what he purported to be a marriage certificate. However, it was not signed by anybody who is authorized to perform a marriage, nor was it witnessed. So we believe this was just an application for a marriage license and not an actual marriage certificate. Lastly, this court has previously ordered the use of Our Family Wizard. And finally, the plaintiff is using it. However, he's now using it as a weapon, telling the minor child, I can't communicate with you unless it's on Our Family Wizard. The order is very clear. That is for the parties to use and communicate with each other. That is not for the children. It is not expected that a child communicate with a parent through Our Family Wizard. Yet the plaintiff continues to contact the minor child and state, I can't talk to you. I have to block your number because I can only talk to you in Our Family Wizard. Lastly, the court did order counseling between plaintiff and the minor child. To date, this was ordered November 15th of 2023. It's been almost a year now. The plaintiff has not begun that counseling. My client has had an intake appointment with Margaret Hunter, who will handle this type of counseling completely on Zoom. So despite the fact that plaintiff does not live in Calhoun County, it is not a barrier to him participating in counseling. This was testified to at our last referee hearing in June, and still the plaintiff is yet to engage in any of this counseling. So we're asking the court to grant the relief requested as it relates to parenting time exchanges, the location of parenting time, to begin counseling with the minor child and Margaret Hunter, and to unblock the minor child's phone number and understand that Our Family Wizard is for the parties to use, not the plaintiff and the minor child. Thank you.
Okay, thank you. Mr. Irons, go ahead.
Your Honor, on our family wizard, I would just like to state when you log into there and it goes to subject and it also states like what are you on there for? It says Abigail Kidder and it says Dewan Irons. So under my impression, that is what we're supposed to use to communicate. Also, I was indicated that by Mrs. Kidder that I need to communicate on there. So my son, our child, Dewan, he calls me a lot, like regularly on the phone. But I told him that I have to communicate with him on our family wizard because that's what I was told, and that's where his name is indicated. So if he's not supposed to be on our family wizard communicating with his father, why is his name listed as one of the parties to communicate with on our family wizard? So maybe there's some discrepancy or some misunderstanding, but as far as what our family wizard states, his name is on there. So I figured that's where I'm supposed to communicate with him and not on the phone. So once I found out, hey, oh no, he still calls my phone, so I unblocked his number. But I'm confused with that part, Your Honor.
Okay,
Just to
well,
have that.
let me clear up the confusion then. Our family wizard communication is just for the parties in this matter. There's no prohibition against contacting your son on his phone or him contacting you in this matter. So there's no need to have him blocked or anything of that nature. So you can continue to communicate with him vis-a-vis phone or any other method necessary. What the court can do on the relates to the exchanges is provide that again, when the exchanges occur, that the plaintiff would have to wait the 30 minutes after the exchange time. And if the defendant does not appear within 30 minutes, then he forfeits his parenting time, whatever that parenting time would be. If it's a weekend or a week or whatever, he forfeits that available parenting time. If he is in fact at the exchange point more than 30 minutes after he's supposed to drop the child off, then he forfeits his next available parenting time. So whatever the next available parenting time was, if he's there past the 30 minutes, when it's required to drop the child off, then he forfeits his next parenting time. The court would order that the plaintiff would commence counseling with Margaret Hunter, that he would have an appointment set up, and he would set that up within the next 30 days. And I think that addresses all of your issues, Ms. Podolsky. Is that correct?
Just the last item being the location of parenting time. It's our understanding that Mr. Irons does live in Lansing. When the minor child was having parenting time there, he at least had a bedroom and a bed, and he was fed. That's not happening at this home in Albion. So we're asking that parenting time not occur in this woman's home because of all the reasons stated.
I'm not going to order that at the current time. If in fact it is not an appropriate environment for the child, then you can always contact Family Children's Services and or Child Protective Services, I'm sorry, and get them involved to see if it is not appropriate. Mr. Irons, I think you were trying to say something.
Yeah, I was just trying to address the issue of concern of parenting time with Dewan and Albion. I would agree, meaning I am agreeing to the fact that he does not need to spend his weekends there. He is, to spend his weekends with me at my home.
Okay. Well, we can include that in the order if that's agreeable. And that is at the home in Lansing, sir?
Yes, Your Honor.
Okay. You can include that then, Ms. Podolsky.
Okay, thank you.
And
For the weekends, he said.
I don't think I've ever been accused of not feeding a child in my house, in my care. Even a person. Oh, speak of the devil. There's my child probably calling for money for food. Let me answer that.
said.
Right, correct. And also, Your Honor, I would like to address the issue of pickup and drop off.
Well,
The only
I've already
reason is-
decided that, so we don't need to address it. I'm sorry.
It's just the time.
There's a 30-minute window and that's it. So,
But I don't get out of work till 5 o'clock. How can I make it from 5 o'clock to Marshall? It's a 45 to 50-minute, maybe an hour drive, depending on the highways lanes closing down. Like, I get out of work at 5. He expects me
gonna
to
have
be
to
there
make-
at 5:15.
okay.
I have to
Is
quit
there
my
a problem
job.
with going later, Ms. Podolsky, like having the exchange occur at 6:30?
The only issue is my client is at work by that time, so she would have to make arrangements with a third party, like the minor child's grandparents, to then be there every other week to make that exchange.
Well, why don't we try that and see what we'll do, sir? We're gonna move it to 6:30 PM and see how that works. If it doesn't, then we'll have to work on something else.
It will work. I will make it work, Your Honor.
Okay,
And will the Sunday pickup continue to be 4:30 as ordered?
you don't have any problem with doing that at 4:30 on Sunday, do you, sir?
No, that's fine, Your Honor.
Okay. Include all that in the order, Ms. Podolsky, and submit under 7-day.
I will, thank you.
Okay, thank you. You're free to go. Have a good day.
You as well, thank you.
Two.
Versus. Case 2022-2884 DM Alicia Hans versus Floyd Hans. Today is Monday, October 14th, 2024 at 9:24 a.m.
Court will note the appearance of Ms. Capture on behalf of plaintiff, Ms. Town on behalf of defendant. This matter is before the court on the defendant's objection to the referee recommended order dismissing the motion and motion to set aside recommendation. Ms. Town.
Good morning, Your Honor. Can you hear me okay?
Yes.
Thank you, Your Honor. Yes, we are filing an objection regarding the motion, or the order that dismiss the motion based on no change in circumstance. So this judgment of child support was entered back in January. The parties signed off on this in December. At the time, it is true my client did not have a job and income was imputed to him at that time. But since that time, 10 months later, well, actually 3 months later, he obtained new employment. He's earning somewhat less than what he made at the last job for an hourly rate, but he's not getting the kind of overtime that he was making from his prior job. So there's clearly a change in circumstance in this case because he is employed now, he is earning an income, he is paying his support, the support of which happens to be more than 50% of his disposable income being deducted from his paycheck, which, as this court knows, is not.
More than 50% of his, well, hold on, disposable income? Did she just say? Did she just say more than 50% of his disposable income? Oh, how lucky for him to have disposable income. I have none. But what I will say is that was a call to the Bank of Mom. As usual. You're not modless, by the way. I'm a mod. I'm the ultimate mod. As we know. Sorry, I have to send her this. This child takes all of my income. But that's par for the course. Par for the course. She knows what to say to get me to give her money. She just says, please, mommy. And I'm like, okay.
Allowed by state and federal law. It's consistently causing him to become in arrears every single month because the support is higher than what his income is every single month, and he's still making an effort to attempt to pay it. The court, or the front of the court in this case, just said that they're dismissing it based on no change in circumstance. The circumstances have been over 10 months. He's been trying to pay his support and catch up after obtaining this new employment in March. The the support has to be modified just on that change in circumstance alone, but we are requesting that de novo hearing. I understand that Attorney Capture is attempting to argue an imputation, and I appreciate that argument. In this case, however, my client's already working 40 hours a week. He is not able to earn the prior income that the support was based on. He can show that in a de novo hearing and show what the support should be based on with that respect. I'm going to also refer to imputation of income. We've got the Michigan Child Support Formula, Section 2.01G. So the case cited by Attorney Capture is the roll-off case from 1987. The child support formula has been modified significantly since that time. It clearly says even if there's a crime committed, that's not a basis to impute income. I understand my client, he did not voluntarily quit his job. He was terminated. I understand it was based on his misconduct, but he's attempting to earn an income, pay his support timely, but in a manner that's consistent with Michigan law. So we are asking that the court let his motion go forward on the modification of support and grant him the de novo hearing, which he's allowed by law.
Okay, well, I looked at Ms. Capture's response, her answer. She states in paragraph 13 and paragraph 15 that in fact your client was terminated prior to the last order, and that was a consent order. He consented to the imputation of income. Is that right?
My understanding is that it was a consent order, that at the time he was contesting the termination of his employment, that even if it was continued to be terminated, he would be able to find employment somewhat at that level. He has not been able to do so. I might myself agree with Attorney Capture's argument if my client had filed a motion to modify, say in March. But we are 10 months later now. He filed this motion in August. He's climbing, this is an uphill battle. He's not going to can't be able to go above and beyond the support arrearage that's taking more than 60% of his income out, where they can't do it, they can't withhold it. So he's not able to pay that level of support anyway, and he's already working more than 40 hours a week, quite frankly, on a number of these weeks, with the income level that we alleged in our motion, that would be even more than his 40 hours a week as well.
Okay. Ms. Capture, your response.
Thank you, Your Honor. Like you just stated, this was a consent order. Mr. Hance did realize that he could have imputed or agreed to an imputation at a lower level. However, he did not. Furthermore, again, the change of circumstances may have occurred back in March. However, he didn't even let FOC know until I believe July, when he finally started making child support payments. He had significant arrearages until August. And I believe his most recent arrearage didn't clear until we had worked out a consent agreement between ourselves and Mr. Hance to allow for the funds that were to be used in the equitable division of the divorce. Those funds were released to pay back due child support. So again, as I stated in my answer, Mr. Hance went and bought a brand new vehicle. He's been making regular payments, assumedly, on that vehicle. To say that he is unable to make these payments.
He bought a brand new vehicle? Oy, 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 oy. That's not a good sign, bud. Like, oh, God. Well, if it makes you feel any better, San Francisco is possibly one of the better places to be outside. That's just the way that is. But, stuff being stolen, I don't know. It's tough. If those of you that don't know, my daughter is she's 15, turning 16, so a little different than a 39-year-old child, obviously. But I think that it's hard as a parent. It's hard when you go through and do all these different kinds of things. It doesn't help when you're fighting the other parent like these two are. But again, your kids will remember all this kind of stuff. You know, your kids, I'm talking to these people now. They're going to remember daddy having a new truck and mommy bitching about child support. And, you know, it may not be fair, but I'll just say, like, whoever is in the ear of the child more often is going to be the one that pays more dearly at the end when the children get older, become adults themselves, have to make adult decisions for their own children, perhaps, and they recognize, oh, well, this isn't difficult. Like, for example, I don't badmouth my daughter, my ex-husband, ever to my daughter. Like, it's just not in my realm. I don't involve her in those adult issues. It's just not the way that it goes. Never have. And not like not involving a child in issues, but like really they're very well aware of it, but just like literally that doesn't exist. Based on, because I remember the issues from when I was a kid that were not involving me, but I still heard about them, heard people talk about them, all that kind of stuff.
Is not true, because he also doesn't have his own residence. He lives with his father. He doesn't have any costs associated with that. The fact of the matter is, Your Honor, is we don't have a change of circumstances here. He agreed to the imputation, and he was fired prior to that imputation occurring. He was also fired due to his willful actions. Yes, the roll-off case is an older case, but that does not change the fact that it should be construed as a voluntary termination. Thank you.
Okay, thank you. Ms. Town, anything else?
Again, Your Honor, the court would have to go through very specific factors to be consistent with the Michigan Child Support Formula to impute this income to him. I understand the issue is change in circumstance. I assume that if Mr. Hans had obtained a job where he was making significantly more than the $75,000 that was imputed to him, that Attorney Capture and his client would be asking the court for a change in circumstance. So I'm not sure how it could be perceived that there's no change in circumstance when there has been new full-time employment gained.
Okay. Well, in this matter, clearly, and it's acknowledged today, as well as the pleadings, that the defendant had entered into a consent judgment, a consent order in this matter, again, acknowledging that he would pay the support based upon the imputed old income. So the court, basically, the parties have an agreement as to that particular point, and you can't say, okay, well, 3 months later would be the appropriate time to change that, or 10 months later, whatever it might be. Obviously, he knew at the time that the order was entered into that he wasn't making that kind of money. He did not take advantage of, again, a recognition of that, but in fact agreed to be imputed to that. The court would, however, recognize that Mr. Hans, as stated by Ms. Towns, is not getting the overtime, so he does have a reduction there, which would not be something that you would take into consideration. So what the court will do is the court will continue the imputation at the amount of the other order at the hourly rate from the other one, less the overtime. So again, if he's not getting the overtime, the court would not impute that amount, but I would continue the imputation at his hourly rate from the prior employment. So Ms. Town, I'll let you and Ms. Capture work on figuring that out, but his hourly rate would continue imputation, but not the overtime that he had from the prior employer. And then you can recalculate support based on that.
Okay. Just to clarify your ruling, Your Honor, I know this court's busy. Your ruling today is to recalculate based on his prior hourly rate at 40 hours a week.
Yes.
And then this is retroactive to the date he filed his motion.
Yes, to the date, well, date of notice of the motion. So you'd probably be I was gonna say 3 days, but the mail is probably about 5 days late, so I have a 5 days after your filing.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
You have a good day as well.
Thank you, Judge.
Okay, we're gonna save the rest of that. We've got one more. We've got a Bronlick hearing that we're gonna watch, and then that's gonna be it for this morning. Oh, the green screen again. Corey, are you lying down in bed? Oh, look, Credence and my key premieres.
Morning, Judge will be out in a moment.
Thank you.
Gotcha.
What's this third party?
I'm sorry, what?
I was just asking what it says the content of the meeting is being sent to a third party.
That's me! It's me!
Well, we have the court recorder and the clerk here.
And me.
Oh, okay.
I turned off my notifications now.
Andrea, how are you? Good morning, Mr. Walker.
Good morning, Your Honor.
You ready, Judge?
Yes.
Michigan again.
Salo Pope versus Corey Salo Pope.
Record is matters before the court. Pre-trial conference subsequent to parties have engaged in mediation with Mr. Walker from the front of the court. Again, this hearing is being conducted via Zoom. Appears we have both parties present. Bradley Solo Pope and Corey Solo Pope. Good morning.
Good morning.
Mr. Walker, have the parties been able to, with your assistance, reach their own agreement?
Yes, Your Honor, the parties do have a full agreement.
They have a full agreement. What is going on behind her? Is that a mirror that's showing an opening games to the Olympics or opening ceremony, it looks like, on the screen? Let's hear what their agreement is. Maybe it's good. Maybe they got along. These two fucked, by the way. Just remember that. Think of that for a second.
And I believe Miss Solo Pope has a blank judgment of divorce that she will be submitting to the front of the or to Your Honor for signature as soon as she can fill it out and give it to Mr. Solo Pope to sign.
Okay, so Miss Solo Pope at the bottom, the second or the last page of the judgment, you need to sign it and date it. You need to then maybe sit down with Mr. Solo and you can both go through it together, and you both need to approve it before you submit to the court. You'll not be divorced till the court signs written judgment.
Understood.
Mr. Walker, could you please state what you understand to be the parties' agreement, please?
Yes, Your Honor, I can do that. In regards to custody, but let me start with this. The issues of custody, parenting time, and child support are all going to be referred to the front of the court for a report and recommendation. Each party is going to have 21 days to object to that recommendation. If there is no objection, then it will become an order of the court. In the meantime, custody on a temporary basis is going to be sole physical to mother, and the parties are going to share joint legal. Parenting time is going to be reasonable and liberal as the parties agree. The parties are going to text each other every Sunday and have an agreement for that week's parenting time schedule. And child support itself, as I already mentioned, is going to be.
My ex-husband and I did that we did that because he worked at a job where he got his schedule basically like the Friday before for the next week, because he was covering people's it was bad scheduling at his workplace basically. But for like I think 4 years I every week changed my schedule to accommodate his schedule and allow our daughter to have parenting time with him whenever his day off was, because that's what you do to co-parent, and I had a more flexible job.
Be referred to the front of the court The effective date of child support is just going to be whenever the recommendation is issued to the parties. For tax purposes for the minor children, mother is going to claim the minor child Nadia every year, and father is going to claim the minor child Keegan every year. There will be no spousal support. It is forever barred as to both parties. Each party is going to keep their own debt. There is no joint debt. Each party is going to keep their own bank accounts. There are no joint bank accounts. There is no real property to be divided. Personal property is going to be divided as the parties agree. The parties are going to keep their own retirement accounts. The parties are going to keep their own life insurance policies if they have one. And as far as vehicles are concerned, there is a 2007 Ford Expedition. Brandy is going to keep that vehicle free and clear, and she will be responsible for any liability. The title is already transferred into her name and her name only. There is also a 2012 Chevy Equinox and a 2012 Kawasaki bike. Both of those are going to be Corey Solo's or father's. He will be responsible for those and hold Miss Solo Pope harmless. The titles on those are also in Corey's name alone. And I believe, Your Honor, that is, oh, one more thing, maiden name, Miss Solo Pope would like the opportunity or the availability to be able to change her name to Watson if she so chooses. And I believe that is the extent of the agreement.
Thank you, Mr. Walker. So there is no real estate, is that correct?
That is correct.
Okay, the pretrial statement, the court noted that there was real property division. So maybe that was marked in error when the court originally talked with the parties. Wonderful. Ms. Brandy Solo Pope, did Mr. Walker accurately state your agreement? And I'm sorry,
Yes.
you're muted? Okay. Obviously, once the court signs a judgment, if you want to be restored your former name, you need to take that judgment to the Secretary of State and Social Security to facilitate that change. Just keep that in mind.
Okay.
Is it a soccer game?
Mr. Solo Pope, did Mr. Walker accurately state your agreement?
Yes.
Wonderful. In terms of division of personal property, you've been separated since May. Have you each, obviously the court suggests divide that up as soon as possible. Don't drag it out for months.
Well, we already separated most of our stuff that we were going to separate anyway, other than two to three things and a couple little odds and ends.
Okay. And
He
so
just has to
obviously-
pick them up.
Okay, so yeah, I would say if you've agreed upon those, pick them up as soon as possible. Just sometimes when the things sit for too long, they become a problem. So divide that up as soon as possible. Well, and you, of course, you need to write in the judgment, Ms. Solo, that the even though on a temporary basis got joint legal physical to mom, reasonable parenting time, you need to put some language in there that the issues of custody, parenting time, and child support are referred to the front of the court for investigation recommendation.
Yes, sir.
Right, so Mr. and Mrs. Solo Pope, can you both raise your right hand to be sworn, please? Do you both solemnly swear affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yeah.
Okay, we'll start with you, Ms. Solo Pope. Please state your name and current mailing address for the record.
Did you say Mr. or
Ms.
Mrs.?
Brandy, can you please state your name and current mailing address for the record?
Brandy Solo Pope. Flat Rock, Michigan, 48134.
Ms. Solo Pope, is it true that you filed a complaint for divorce with this court on or about
Yes.
May 30th, 2024?
Yes.
Is it true that on the date you filed the complaint, you've been resident of the County of Monroe for at least 10 days, the state of Michigan at least 6 months?
Yes.
Is it true that you married Corey Solo Pope on June 1st, 2021? You separated in May of 2024?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any reasonable chance of reconciliation?
No.
Is it true there were 2 children born of your marriage, namely Keegan and Nadia?
Nadia, yes.
Nadia, were there any other children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Do you have any questions for the court?
No.
All right. Mr. Corey, can you please state your name and current mailing address for the record?
Corey Solopoke, 41761.
Temperance is 48182, is that correct?
Yeah.
All right. Mr. Pope, did you hear the testimony of your wife this morning?
What was that?
Did you hear the testimony of your wife this morning?
Yes.
Was her testimony true and accurate to the best of your knowledge?
As far as I'm aware, yes.
I'm sorry?
It says, as far as I'm aware, yes.
Okay. Do you have any questions for the court?
No.
And one last issue needs to be addressed, and that's a fee waiver that was previously addressed with both of you at the last pretrial conference. And Ms. Solopope, are you still receiving public assistance?
Yes.
Okay, Mr. Solo, the court's going to require, in order that you pay the filing fee of $255. If this court cannot order Ms. Solopope to pay that, she's in public assistance. If she wants to contribute toward that, fine, but the court cannot order her to do so.
Your Honor,
I'll give you as much time as you need to pay that. $255 paid to the Monroe County Clerk. And court will give you as much time you need to pay. Just don't blow it off. Blow it off after a bench warrant's issued. I'm sorry?
I'm on state decisions too.
Are you disabled?
No.
Okay. You're unemployed?
No, I'm working.
Okay. I'll give you as much time as you need in which to pay that filing fee, $255. Pay it to Monroe County Clerk. They will not take a personal check. If you pay by credit card over the phone, but they're going to charge you a fee for that, you're best off just coming in and paying the $255 cash. And you need to, that needs to be written in the judgment, Miss Pope. There's one of the pages talks about a filing fee. You just reference that's to be paid by the defendant, Corey, and we'll provide a date for that. Mr. Solo, do you need a month to pay that?
I mean, I'll try my best.
Okay, well, give me a date that you think you can pay it. You need to put you pay it by the end of October. Do you want the end of November?
End of November at least, please, because I got 2 other children as well.
Okay. All right, so we will, and the court will make a note that the court will add that language to the judgment if it's not been added, and I'll put my initials next to that. The defendant, Corey Solopope, shall pay a $255 fine fee to Monroe County Clerk. Are we open on the 29th of November? Okay, the last business day that the court has opened November is November 27th, the day before Thanksgiving. And Mr. Solopope, let's say that you can't pay, then you call my office and I will give you an additional month. Just don't blow it off. If you blow it off and you don't ask for more time, that's when bench warrant's issued. Well, it's not, we wouldn't want to go there, okay?
All right.
I don't know why he doesn't get the fee waiver just like she does if they're both on food stamps.
Okay, court, please, everything has been covered. Again, do either of you have any questions for the court?
No.
No.
Are you going to both sit down together and complete that judgment together, Ms. Solopope, or how are you going to get that to Corey?
Our children have a doctor's appointment today at 2:40. We'll be together. We can complete it together.
Okay, and deliver that to the court. And once the court's received it, the court will sign it, and then that's when you'll be divorced, and then you'll both be mailed a copy. Again, do either of you have any questions?
No.
Right. The court applauds you. Thank you, Mr. Walker, for your assistance and helping the parties reach their own agreement. The court applauds you, 2 of you, for reaching your own agreement. Your children will thrive if you're on the same page. Please keep that in mind. You know, obviously, you've got 2 children in this world. There's enough challenges in life, so make it good for each other.
Mike, I was thinking the same thing, although I don't call it scamming the system. I know in America there are certain cases where people medically need to be divorced in order to require support, but they don't act like this when that happens, because like this is real. This is real emotion from both of them. Something happened. Something broke them up. It might have been an ultimatum that she made that she's sticking to. I think that might be where I'm leaning. Either a cheating or drugs, I would guess, allegedly. But there's still love there.
And communication is the key. Communication in terms of your schedules, that of the children. You know what's best for your children. Again, obviously, there may be some issues regarding parenting time in the future. And if you cannot reach that agreement yourself, then you're asking a total stranger like the court to make those decisions. Hopefully, you not need to come back and ask the court to make those decisions. And of course, once you receive a recommendation regarding the custody parenting time, if someone wants to modify the custody parenting time, someone needs to petition the court. You have a friend of the court caseworker. So if you have any questions about this case in the future, you can reach out to your friend of the court caseworker. You are both assigned a caseworker. Mr. Walker, do you know who their caseworker is offhand?
I am not sure, to be honest with you. I don't think I have a list of, because these workers were just reassigned not too long ago, and I'm not sure.
Okay. So just once you got your judgment of divorce, if you have any questions in the future, you contact a friend of the court, and there's a caseworker, the same caseworker assigned to both of you in this case, so they can answer questions for you and help you. Okay. All right. Thank you, Mr. Walker. Based upon the testimony that's been presented this morning, as well as complaint files, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment approved by the parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter, granting a divorce from the bonds of matrimony. Good luck to both of you. I mean that sincerely. Now we'll conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
Ms. Pope, you can bring that judgment up to the fourth floor, up to the Bronx office. Okay, when you bring that down to the courthouse. Okay.
Yeah, that one didn't sit very well. That one didn't sit very well with me either. Hatred is fine. Compassion and love, regret, he also said he has 2 other children. Anyways, I hope that you guys are gonna have a better rest of your day than they are. I know it's a holiday in some parts of America, some ways, but I urge you to join us over at Credence and Mikey for the chase today at 405 East. And then I will be live again tonight. It'll be either 4 Pacific or 6 Pacific. I haven't decided yet. It'll depend. I'm going to go back and look at that. Actually, I think it'll be 4 Pacific. 4 Pacific, because we'll do the Thurston County one. Anyways, I love you guys so much. Thank you so much for being here. I really appreciate it. I hope that you had a great day and that we are going to continue having a great day together. All right, remember that I love you, I'm proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.